I held him on to you and
hold
I
on,
put it to him.
Please. He didn't withdraw.
You didn't?
He decided he didn't withdraw.
Why?
He refused to withdraw. You see, listen. The next time you call me to debate Vincent, I will not.
No, Vincent,
because
hold on.
Okanse, he doesn't respect himself.
No.
He doesn't respect himself.
Listen.
He doesn't respect himself.
Gentlemen.
But let me address the matter.
I referred to both of you as being honorable members of parliament. When Vincent,
let me address the matter.
I asked that you withdraw it. So please.
Let me leave him. Let me address the matter. Vincent, as if for honorable, is insisting on something that does not exist. There's a very, very famous authority in UAC versus McFoy that you can't put something on nothing and expect it to stand. He began this propaganda by saying, NDC government, we have deceived law students, we have deceived the country, the president is never going to assent to this bill. And I checked him. I told him that he, as a lawyer, as a member of parliament, knows that as part of our new regime of passing legislation, there's something we call a post-passage legislative scrutiny to ensure that all that...
Whenever I say my PENDREAM TV there, I see them, you
to be in order, because you have been leading this particular campaign and for this bill and be passed into law on the floor of parliament. With what I have just run through right now, what are the major effects of this law that has come into force now on the previous legal education regime as we had it until today?
Now, let me use this opportunity to thank His Excellency John Dramani Mahama for doing this, because if you recall, sometime last week or so, the propaganda went out that he was never going to assent to this bill. All manner of things were said, but here we are. Now, the major effects include, one, the establishment of the Ghana Law School, as it were, as a directorate of the creature under Section 1 of the law. The Section 1 of the law creates what we call Council for Legal Education and Training. And so the law school has been properly established by this Act of Parliament as an entity. It was established in 1958 by a policy executive decision, by a policy of the then Prime Minister Nkrumah, who decided to establish the law school, arguably one of the first in sub-Saharan Africa. So it was not backed by any Act of Parliament, but this time we are establishing it by this law act. Now the law is Act 1170. That is Act 1170. That is the full name of the law. Now the other effect is also that it's taken away the monopoly hitherto or until this morning enjoyed by the Ghana School of Law. And so that monopoly will no longer they no longer have the monopoly. They will be joined by all the faculties of law. They want to be called law schools, both public and private, who train law graduates now. That is for purposes of obtaining the LLB, to apply to be licensed to train those graduates in the professional programs, in addition to what Ghana School of Law will be doing. So the distinction is that whilst the law schools, the universities will be licensed to produce both LLB graduates and to also train them in the professional courses, Ghana School of Law will be licensed to only train in the professional courses and run programs for the post-law course program for lawyers who have been called to the bar in analogous jurisdictions with Ghana, and such other related programs that the Ghana School of Law may want to pursue. The other major reform is that we are reforming the curriculum at the LLB level to include a lot of practice-oriented programs, so that if you read the provisions carefully, the LLB course content will be more oriented towards to producing practice-oriented lawyers, even before they get onto the professional level. Then also we are shortening the time of training. For the professional is going to be 1 year. Then at the LLB is going to be 3 years across. But the intensity is where the issue is. We have rather heightened standards, toughened standards, and so you are going to have a much better lawyers coming out of this system than the existing system used to produce.
I see.
Yes. Then, like you said, persons are going to have the opportunity to write the national bar exams after they qualify from the professional school. So what will happen is that people like me are advocating for a 2-cycle exams in a year. So for instance, we could write the first one in January. If you pass, then you get called to the bar in March. Then the second one will be done in July. You qualify, you get called in September. So if you fail in January, you prepare and take it again in July. Just like that, around the clock.
I see. Now, let me start from where you ended. So you're saying that this current system is going to be tougher and also improve on the quality.
Yes, it's more tougher, especially with the curriculum that is going to be introduced. It's much tougher. I can assure you, it's much tougher than the current system.
I see. How tough is this going to be?
Because the courses are practice-oriented. So even at the LLB level, we are introducing programs in drafting, in courtroom advocacy, courtroom practice. Moot courts at the LLB level is only limited to law week celebration and engaging in moot court competitions. That's all. It wasn't part of the everyday training. But now the practice aspect is going to be part of the curriculum from year 1, year 2 to year 3 once you graduate. And then you move on to the professional stage and do purely also practice-oriented programs. So even if it's civil procedure, it's going to be evidence-induced. Criminal procedure is going to be evidence-induced. Civil procedure itself, conveyancing, all those things. But there's going to be a courtroom aspect of the training as well.
I see. And I asked this question about how tough this is going to be because one of the concerns that was raised about the system that existed until now that this law has been passed to reform it was how tough the entrance exam was, which was like a cutoff for a lot of people to not be able to get into Makola and then be called to the bar. Now, one of the objectives for bringing this was to improve access and then be able to as well give a lot more opportunity to people to practice the law. Now, if this is going to be tough, I mean, as you're putting it, then does that not defeat that purpose of, as it were, improving and getting more lawyers?
At all. Don't let anybody create the impression that law students fear exams.
No, not at all.
Law students anywhere. The training you are built for exams. So as for exams, law students love to write exams. But the problem that we had under the old system was that we had a certain limited access
to obtaining professional legal training. Only one school since 1958, one single mono law school. The population of this country has ballooned since 1958 from about 6 million or 5 million to about 35 million as we speak. We have not enlarged the access. It's still only one law school. So when I qualified from Faculty of Law, University of Ghana in 2007, we just walked chest out and entered Makola. No exams, no interview. Why? Because the numbers were not big. So nobody had issues with controlling numbers. But numbers subsequently ballooned. So in a way to check how many the school could take at a time, they had to introduce entrance exams. Then they also had to introduce interview. So if you recall, in 2017, 2018, students brought petition to Parliament. And I'll find that petition and send to you. So it engaged my committee. That time I was a member of the Constitutional League. My chairman was Ben Abdallah. Ben Abdallah Banda.
Yes.
He was my chairman. We interrogated the matter and sent a report to the floor.
Okay.
We recommended reforms, but the government at the time refused to listen to us. If you read that report, very, very comprehensive, about 8 pages. So it was that decision by our committee and decision eventually by Parliament that eliminated the interview.
Okay.
If you recall.
Right.
We took away the interview.
And now,
and then they introduced what they call LI 2355. But it still didn't reform the system well enough. So even though exams was being conducted, it was still fraught with irregularities. So because people write the exams, they will tell you cannot even ask for a remarking. You can't even see your script. In all sorts of those things, if you read the rubrics, students were asked to write away their constitutional right for asking for a review. Even a court of law makes a decision is appealable.
I see.
But the IEC will organize examinations.
Yes, I'm going to go to... Right.
Yes, but let me finish quickly. So the new regime has done away with the entrance exam. There's nothing like entrance exams under this new dispensation.
I see. That's where I was going to. That if you say there's nothing like entrance exam, does that mean that, for instance, those who are preparing for the entrance exam this year, in the next less than 6-7 weeks or less than 2 months, they will not write the entrance exams?
Who is asking them to prepare for entrance exam? Nobody has done that.
There was a notice that was put out by the General Legal Council.
Okansi.
Yes.
You see, sometimes don't let us pay attention to some of these hearsays.
No, there was a notice. No, this is not a hearsay. A notice that was published.
No, it's a hearsay because it wasn't authenticated. That was not authorized by IEC. It was done by some busybody.
It was actually on their website. That's where we saw it.
Hold on. If you check the first notice that was published, so published, it actually contained a 2025 date. Do you know that?
Yes.
Because I saved that one. Then it was subsequently changed, and then they included a 2026 date. I have done my checks. It was never sanctioned by IEC.
I see.
Nor the law school. I like to check things before I speak to them. It may have been done by some administrative officer, but he didn't have authorization. So it has subsequently been pulled down. So anybody who is insisting on relying on it is actually relying on a hearsay. So because in the new law, if you read section 90 of the law, which is a revocation section, we have revoked the power of the IEC to conduct any entrance exam. If you read it, we say that Regulation 1 to 22 of LI 2355 2018 is repealed, completely gone. They don't have any power to institute any entrance exams.
I see. Now, here's where I bring in. Hold on a bit for me. Vincent Eko Asefua is also a private legal practitioner, your learned colleague. albeit you are senior. He's showing us on the other line as well. He's on the other Zoom. The Honorable Vincent Asifua, can you hear me?
Yes, Alfred, I can hear you.
Perfect. That issue about the entrance exam was one of the major things that you wrote about as well in that write-up about 3 or 4 weeks ago. Does this explanation and the legal effect of what's happened today answer the questions you were raising about this entrance exam?
Alfred, I think that people like Dafia Mapo should stop insulting the intelligence of Ghanaians, more especially the intelligence of law students.
What do you mean?
Please, Alfred.
It is.
Alfred.
No.
I think Alfred.
He's insulting our intelligence. Listen.
Vincent Asifua, hold on.
Can I make my point?
Hold on.
Can I
Vincent
make my
Asifua,
point?
hold on. I think you could have actually made the point without necessarily having to go on that path of saying people like. I think that in the context which you're using it, I don't think it fits the conversation in any way. So kindly withdraw that and go ahead to make your point.
I have taken my time to read a piece from the Honorable Dafia Mapo. The kind of words that he even used on me, I have been very charitable.
You are not going to settle it on this platform.
He said that on
that's not the purpose of the interview.
On his official letterhead. But let me make my point.
That's not the purpose of this interview. I didn't call you to settle scores. Respectfully.
It's okay. My point is, the Honorable Dafia Mapo cannot insult the intelligence of Ghanaians. You see, you asked him a very simple question. The IEC made a statement through the General Legal Counsel. That communication was on the website of the IEC. You just told him. That statement was on, in fact, the Kwame Nkrumah University of Science and Technology and its Faculty of Law made a publication by way of a memo, which memo sought to communicate that students are supposed to prepare themselves and write the examination on the 31st of July, 2026. Alfred, are we case in this country that if the IEC indeed did not issue any statement like that, and the Kwame Nkrumah University of Science and Technology also did not issue any statement like that, why is it that those institutions are not coming out to formally communicate to the people of Ghana and the law students that, hey, this communication is not from us? We have not seen anything of a sort. In fact, the 24th of April memo that was issued by the Faculty of Law was very clear that there has been a reschedule of the entrance exams to 31st of July 2026. It was that confusion, especially when you ran that with his own interview that he did with Umar Sanda, saying that law students should never even think of going to write any examination. In fact, in his own words, that is in the words of the Honorable Dafia Mapo, it is gone. Meanwhile, you have the institution that is clothed with the jurisdiction as at the time to announce and communicate to law students that they are going to write an examination. It is okay to say that, oh, I have eaten my words back, or the General Legal Counsel made a mistake or was not in consonance with the intent and the directive that is supposed to be made by government as far as the bill is concerned. And for that matter, you would let the Ghana Legal Counsel issue a statement to the law students that that statement did not come from them. If all these things have not been done, why is the Honorable Dafia Mapo pretending to be speaking for the Ghana Legal Counsel, pretending to be speaking to the IEC, speaking for the IEC?
But he just explained that he did his checks and one found out that this was not even sanctioned. That notice you're talking about was not sanctioned, and that's why it has been pulled down.
You rightly told him that that statement or that communication was on the website of the IEC. And that is why I'm saying that it does not lie in the mouth of the Honorable Dafiam Apo to come and tell us that it is a false information. The institution that supposedly made that error will have to come out and clarify, because there's confusion in the minds of law students. Because what is the locus for Honorable Dafiam Apo to determine whether there's going to be an examination or not? I want to understand what is the locus.
But he is not speaking in that capacity as majority chief whip. He's been referencing what he's found out. And that's why, I don't know if you've checked as well, that this same notice that I referenced, and it was indeed on the website of the IEC, has been pulled down. Have you seen this?
It is okay to play the devil's advocate. But when there is a memo from the KNUST Faculty of Law referencing the IEC and the Ghana Legal Council, it is proper that such a communication, if it is false or if it is not well thought through, will come out officially to, as it were, correct the misinformation that has been put out. So it is my contention that it may be the case, as the Honorable Dafiam Apo is saying, but why is he the one trying to give that communication and not the one who, or the institution who actually made that mistake? So my contention all this while has been the confusion in the minds of the ordinary law students as to whether or not they are going to write the examination or not. See, the same act gives authority to the council, okay, to, as it were, give accreditation to these students or to these institutions to be able to, as it were, give admissions to students who will not be able to write or who will not be writing the examination. Let me put it that way. Now, the AG is telling us that this is going to take him like a year to be able to do so.
A year to do what exactly?
The implementation, at least from what I heard from him today. And there has not been any budgetary allocation whatsoever. They are now going to make a budgetary provision in the 2027 budget. Now, how are they going to get these schools who are going to get the accreditation that will be given to a council that is yet to be formed? It is the board that is also supposed to, as it were, bring out an ally to regulate how these accreditations will have to be given. So it is not a joke. And I don't see how all these things are going to be done within these 2-3 months, unless, of course, the Honorable Dafiam Apo and his people would want to engage in any illegality. So there is a clarity that we need from them. Take your cameras out. Go and ask every or any law student if that law student is not confused. All of them are confused.
Okay, well, hold on a bit for me, Vincent Asifua. Nelson Dafiam, can you hear us?
Alfred, I've been trying to catch your attention that if Vincent doesn't withdraw his opening comments,
I held him on to it.
Hold on, please. He didn't withdraw.
You didn't?
He decided he didn't withdraw.
Why?
He refused to withdraw. You see, listen. The next time you call me to debate Vincent, I will not.
No,
because Okanse. He doesn't respect himself.
Listen.
He doesn't respect himself.
Gentlemen.
But let me address the matter.
I referred to both of you as being honorable members of parliament. When Vincent,
let me address the matter.
I asked that you withdraw it. So please.
Let me leave him. Let me address the matter. Vincent Asifua Honorable is insisting on something that does not exist. There's a very, very famous authority in UAC versus McFoy that you can't put something on nothing and expect it to stand. He began this propaganda by saying, NDC government, we have deceived law students, we have deceived the country, the president is never going to assent to this bill. And I checked him. I told him that he, as a lawyer, as a member of parliament, knows that as part of our new regime of passing legislation, there's something we call a post-passage legislative scrutiny to ensure that all the amendments carried are properly aligned and factored into the law. He said, no, because we passed some other laws and quickly the president assented to it. But those laws are not as they are skeletal laws. They are not as heavy as this one. He still won't listen. Today, assent has been given. He's still insisting that there's some clarity. Because why? He is conjuring that there's a certain entrance exams that will surely be written on 31st July this year, when no such arrangement has been put in place. If in fact some registrar at UST relied on some information he saw on some website of the IEC, then that registrar is relying on hearsay, because that information is not verified. So even if he proceeded to do that, it is up to that registrar to put his house in order. It's not me. It's not IEC. It's not the GLC. Second, the budget matter that the Attorney General mentioned was at the tail end of his interview. He opened I was standing right by him. He opened his interview by saying that His Excellency just a while ago has assented to the bill. As a result, implementation is effective immediately, and that he will take steps to establish the Council for Legal. Hello?
Yes. Sorry, there was a little disconnection, but you're back. I can hear you now.
Yes, because somebody was trying to call me. So that the council, which is mandated under the law, particularly under Section 2, Section 3, Section 4, will be able to proceed to receive applications from the universities for purposes of accreditation. How else do you expect a minister to speak? Then he says that because you cannot allocate funds to an entity that does not exist. And I told Asifwa this afternoon that if this government had done that, he, Asifwa, would have been the first person to raise the red flag. That why are we allocating money to an entity that we are here to create? So no government does that. What you do is that you fall on the consolidated fund, the contingency fund, for commencement of the implementation processes. Then in October, when the new budget is brought for 2027, the appropriate budgetary allocations will be done to the office of the council, the director general, the registrar, and all those entities we've set up, including the Ghana School of Law we are setting up as a directorate of the council.
I see.
Vincent says this one, it is strange, he hasn't heard before. So he's insisting that because the minister hinted of a proper budgetary allocation from 2027, it means that the law will be implemented in 2027. When the man has actually said that the implementation is effective immediately, that one he doesn't want to hear. It's so painful debating him sometimes.
Well, thank you very much for this explanation and how the coming days will look like. And in fact, I've got a number of questions from some students reading law and asking questions about whether or not this entrance exam is going to come off. So that explanation
let me address the students. Yes, in 1 minute. You see, the students under Section 90 of the law, the power of IEC to organize any entrance exams is evaporated, it's gone, it's repealed. So that no entity can put up a notice that they are organizing any entrance exam for Ghana School of Law. In fact, Ghana School of Law as it is also gone. It is a new Ghana School of Law that we have established under Section 77 and 78 of the law. So everybody should take their time and study the new law before we make arguments.
Thank you. Nelson Rockson Dapemepo is the majority chief whip and then also MP for the South Dike constituency. Vincent went off the Zoom, so we couldn't get through to him again. But we'll be back shortly after this quick break. Stay with us.
I'm not PENDREAM TV. Now, so far so good. Say open online portal e Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.